Live stream.
You're now talking on the live stream. So
and here we are.
Yeah. So
This
yeah,
is my favorite comedy show, Yogi
yeah.
2012. Awesome.
Wonderful. I'm starting with the shades because it's very bright in here. I don't know where you guys are based, but I'm in Southern California. It was about 90 degrees today. That's why I'm wearing a sweatshirt. Makes a lot of sense. I understand. Here with Mr. JR. Good afternoon or evening for you. How's the weather back in PA?
It's fall. Fall's here. So it's dark in the mornings until about 7:15, and it's probably 45 to 50 degrees. And then by 2 o'clock, it's 75, 80 and beautiful out. The leaves, the fall foliage is pretty much in full force. And it's a good time of year in central Pennsylvania.
I noticed that here at nighttime, it's dark. So it's interesting. We're both dark at night. It's quite a coincidence. Anyway, I don't know if you've ever been out here in the fall in Southern California. It's really fall and winter are really generally pretty nice. So it's literally 85 degrees. And obviously we have no humidity in Southern California. We have other negatives, but not that. So greetings to everybody. We kind of thought, obviously not legal advice, not financial advice. It's nothing any advice. And, as I say, the more you listen to us, the more you'll understand that. What we decided to do is to talk a little bit about a case that we had previously discussed, and we're going to do it tonight. But of course, before we start, I have to just warm you all up. So, life as a professional yo-yoer has its ups and downs. And last week, and it's terrible, but I failed my Braille class. It's a very touchy subject.
Oh my God!
Oh my God! And
those are terrible.
Yes.
Terrible.
And last but not least, bad gardeners are rough around the hedges.
All right, let's move on.
Anyway, I'm sure there's going to be more
law.
Yeah, I'm sure there's going to be more comedy or attempts down the road. I'm going to take off the sunglasses now, so we're back to that. So I wanted to get your we've talked about this, but kind of give me a little background on your. We also talk about this. We cannot pronounce the name correctly, so we call it everything but probably the correct name.
Yeah.
So I'm going to call it Jarkesi, and JR knows what I'm talking about. So go ahead.
So I will tell you, I'm probably going to call it 10 to 12 different names tonight. I'll probably start off with Jaworski and then, be calling it something else in the next 5 minutes. So those of you that have been watching this show now for however long, we have talked about ALPINE versus FINRA, and the gist of of that case is, based on multiple enforcement actions by FINRA against ALPINE. The latest one was a violation of a cease and desist order that was found in an administrative enforcement action by the SEC.
You notice that JR is focusing at the comments and he's being distracted. Do you see that?
I'm really being distracted.
Highly unprofessional, in my opinion. Just my opinion.
So ALPINE versus FINRA, the gist of it was ALPINE's making the argument that FINRA's enforcement proceedings actions are unconstitutional because they don't have the constitutional authority to basically adjudicate and enforce the rules and regulations. ALPINE is arguing that they should be in federal court and have the right to a jury trial and a judge to oversee the case.
Just quickly in response, there are none.
Oh, so at any rate, when we first talked about this case, we thought it was a unique argument. We thought that basically it would go nowhere. Well, lo and behold, it didn't go nowhere. An injunction was found in favor of ALPINE. FINRA appealed that injunction, and it went up to a 3-judge panel in the District Court of DC. and that 3-judge panel agreed with Alpine. And then lo and behold, this Jarsky case appeared out of nowhere, was brought to our attention, and we read over the Jarsky case, and guess what? It was almost the exact same arguments that Alpine was making that Alpine was
All
making
right, I'm gonna
against
stop you
them.
there. I'm gonna stop you there for a second so you can gather yourself. And we were torn, right? So this is going back probably what, 2, 3 months, maybe more. We were kind of torn because when we were looking at the Alpines, Alpine versus FINRA, Alpine in our mind was connected to GTII, which was connected to finger motion. That was
Right.
the connection. So on one hand, we wanted, just in our personal benefit and the benefit of everybody else who's similarly situated, we want Alpine to go down. I'm speaking for myself, but I think I'm also speaking for JR, and that's in part because it benefits us financially, to be honest, and part because obviously they are bad actors. It's clear that they're bad actors and they shouldn't be in it. However, in the action involving FINRA, and I think Wes Christian, a day or two ago in one of these space calls, he said it too. But this is
Yeah.
something we talked about 3 months ago, that we agreed with a lot of the arguments that Alpine was making about the regulatory system. And
Right.
and I know JR is going to continue on his blathering on about Jerkaski or whatever the name of this case is. But one difference, and because we're going to talk about Alpine also, one difference is Jerkesi.
I'm just going to be laughing all night. I'm just telling you right now.
I know Jerkesi involves the SEC, whereas Alpine involves FINRA. So
Right.
we will discuss the difference because there is a difference, and I would say the arguments against FINRA are better than the arguments against the SEC, and we'll explain that. But I'm going to let JR continue his long-winded response.
You asked. So let's go back, Richard, because let's go back to this summer when all this went down. You know, what had basically happened was this Alpine case appeared, this Alpine case down in Tampa kind of landed on my lap, and I sent it to you and said, "Hey, I need some help with this."
Okay, I got to stop one more time. I got to put this whole thing in context. The reason why we're doing this tonight, I buried the lead. The reason why we're doing this tonight is because Elon Musk and Mark Cuban and a couple of other individuals filed friends of the court brief in the Supreme Court in the Jerkesi case.
Yeah,
so
that was an important fact.
Yeah, and Elon in particular has railed about the regulatory system. We have tried to elicit a response from him as to shorting. So this brief is kind of the first specific action we've seen where he's taken affirmative action. So that's why we're commenting on. So that's the context of this. Now go for it.
Well, what I was getting at was, we got pulled into this from the legal aspect because there was a lot of misunderstanding of what was going on with Alpine and the enforcement actions against FINRA was putting against Alpine. And so you and I got pulled into this, and I sent you the documents and we read over them, and then we talked about them, and both of you and I were on a space, and it was in July and it was on a Saturday. And the only reason I remember that is because I was out in the garage and it was hot as hell that day. And we both were saying, look, we realize everybody hates Alpine. We realize everyone wants them to go down, but you all need to be supporting this case because it really was going to the heart of FINRA's constitutionality, that aspect of their enforcement proceedings. So obviously, fast forward to today, where we're at is, the Jarsky case is going in front of the Supreme Court. I think Richard and I figured out it was November 29th. Our oral arguments won't expect a decision maybe until sometime in first quarter 2024, maybe even as late as second quarter 2024. And what happened today was Elon Musk and Mark Cuban and a bunch of other individuals who I don't recognize filed an amicus brief on behalf of themselves, but in support of Jerski. So that's kind of where we're at. Richard and I thought it was thought it was important to kind of read over it and kind of give an overview, because while again it's against the SEC, the arguments are similar, and I would strongly anticipate Alpine using, if Jakarski wins, I would strongly anticipate Alpine is going to cite that as good law and make the argument to the district appellate court.
Yeah, in the J case, as we're calling it now, just to kind of explain what happened there. So Mr. J got penalized for being probably a scumbag broker. And
Yeah,
I don't know, what specifically he was accused of, but that's kind of how it arose. And then in proceedings, because the issue is in the SEC, if you're in the SEC proceedings, you can either have a administrative law judge that is a judge appointed by the SEC, operating under the SEC rules, where they're the judge, jury, investigator, and ruler, or they can take it to district court. So that's the option. And district court, if you were in district court, then you have to abide by the Constitution, since the SEC
right.
is a governmental entity. So the J guys in their arguments basically said that it was unconstitutional because it violated the Seventh Amendment, because they were seeking penalties, money, and there was a right to a jury trial. They also
Right.
said that this is a function that's really supposed to be for Congress. And if Congress is going to delegate that responsibility to somebody else, a private or public agency, they had to be specific about what the standards were. And the claim was there was no such standards to SEC. Basically, go ahead, SEC, you govern as you choose and as you rule, which is how they act. And third part was that there was a violation of the Appointments Clause of the Constitution, namely that this should have been something, these judges should have been appointed by the executive branch, and the executive branch is not involved and doesn't have a direct hiring and firing over that, and therefore it's not constitutional. So they threw out all those arguments. Now, in the brief that Elon Musk and Mark Cuban filed, and by the way, the law firms that were representing those gentlemen and the other gentlemen, I'm sure, charge a lot more than JR and myself. But and notwithstanding their great work product and their super ability, their specialty is securities lawyers, I'm sure. To be honest, we were kind of unimpressed with their brief.
Yeah, yeah. It was not, when it was announced yesterday that it came out, I was expecting maybe a full blown brief, and it wasn't that. It read more like, here's what we think, not here's the issue, here's our conclusion, here are the rules, and this is why. So it read more like what I would call a white paper. But you know what? Let's take a step back, and I wanted to talk about this.
That's two steps back. I'm going to fall over if I keep
You were
on
making
doing that.
fun of me for being long-winded. So, but
Wow.
at least I'm funny, right? So,
Yeah.
but let's
you give people who are long-winded a bad name.
Well, I lost my train of thought again.
Choo-choo.
Oh, administrative law judges. Let's take a step back and talk a little bit about what they are and what they do, and kind of the crux of the argument here. So almost all of these federal agencies have an adjudicatory arm in which they promulgate regulations, they enforce the regulations, and they are basically judge, jury, and trier of fact for these regulations. And that's all done by an administrative law judge. Now, there's kind of two reasons why they would do this. Number one, it expedites things. It moves things much faster.
Theoretically.
Theoretically. The other thing it does is, a lot of these administrative law judges are experts in that particular field. So you're not going to have some knucklehead like me be an administrative law judge for the FDA because I don't know jack shit about food and drugs other than how to eat them and how to take them. So really these administrative law judges are supposed to be the expert. I was promised a soda by oh my god. I forgot I said that the other night. One soda. so yeah, these agencies have their own adjudicatory arm, and that's what they do. And in most instances, it makes sense. But what we're seeing with the SEC and FINRA is it absolutely makes zero sense. And the only reason they have their own adjudicators, as kind of was spelled out in the brief, was, well, they really pick and choose when they want to use an administrative law judge, and that's not the way it should be. We know from FINRA what do we have there? We've talked about this for 10 months now. What you're going through, you have a randomly selected arbitrator to be the judge and jury in your arbitration claim, and quite frankly, the only reason they have these things is by design, because you lose your full breadth of federal rules of evidence and civil procedure, and that gives them the advantage. And so what the Jaworski case and Alpine are doing are really they're chipping away at the constitutionality of the adjudicatory arm of the SEC and FINRA.
Or even more. We'll have to see how it interprets. And just to give you a brief of the brief, so it was so I'm going to call it the Elon Musk brief. We'll call it the Elon Musk brief. Basically, it said that the system
we can pronounce that.
Yeah, basically the brief said in 19 pages that the system was unfair as designed because the SEC was the investigator, the judge, the jury, and executioner, and that it was just fundamentally unfair. And they also indicated that it was fundamentally unfair because people could be facing people with the same issues could have different rights in terms how they defend their position. Let me explain that in Polish. So if you had an administrative law judge, so if the SEC decided, let's do this in front of an administrative law judge, your rights would be much more limited than if you go in front of a district court and you have certain constitutional protections or greater constitutional protections than if you were before an SEC administrative law judge. And that choice was solely the SEC's. So and it could be people with the exact same issues. So it really doesn't make sense for the SEC to let one person have certain rights and let another person have lesser rights who are facing the same issues. And that's basically the argument of Elon Musk. And Elon, you should have gone to law school. You would have made a great lawyer. But that's the point as to that. Now, what we think, and I find this interesting, and I'm going to try to explain this. Going back to Alpine, so that's now up on appeal, and the appellate court is going to decide, depending if that injunction is valid, or they might decide that the whole prosecution of Alpine was not valid. We'll see what the scope of things are. So now I'm going to go a little sideways. So the courts are supposed to decide things as narrowly as possible, and they're not supposed to decide issues that they don't have to decide. That's just kind of the basic philosophy. So in the Alpine case, the issue is really the injunction. So there are certain requirements for the injunction, and even though in the discussion about the injunction, the same constitutional arguments may come up and may apply, Alpine still may not be entitled to an injunction. And the reason for that, and this is the way I think about it, The reason for that is to get the injunction, they're going to still have to show that they acted in good faith and have equity, that they are good actors. And it hasn't been addressed. Wasn't addressed by the 2-1 court upholding the injunction, and it wasn't addressed in any of the papers that have been filed yet. But I would expect FINRA, and I'm advising FINRA, not legal advice, that you should be hitting that home. That the lack of good faith and their misconduct should be all over that, and it really should make a difference. Because all the other points, if they have unclean hands, they're not entitled to an injunction. So that would end that. Now, that doesn't mean that would end the issue, because it still may end up in federal court, and the original proceeding where they were found to have acted as scumbags in April of 2022 might come back and might be revisited. But if the courts are really narrow, they might still deny the injunction and make Alpine run through hoops. Now, I've mentioned this many times, and I'm going to do it again, that I think that all that is kind of side stuff. And if FINRA or the SEC, either one, or it might be the DOJ too, I don't know. If they wanted to, they could go into court in New York. They could get a receiver appointed to take over the business of Alpine, if in fact, because the reason why they got to the point where they were seeking to expel Alpine in an expeditious way is because apparently there was 35,000 violations. So if in fact the SEC has that evidence, they don't need the disciplinary proceedings. They can go straight into court and put those guys out of business. And that's what I have been suggesting all along. And I think all this other stuff is interesting, and it may be helpful long term, but I certainly wish that FINRA or the SEC took my instruction or direction or suggestion and did that, because I think it would get us a much quicker outcome. I know you were going to say something, so go for it.
Yeah, I was just going to say, I know we've talked about that, but I would just not expect them to walk in and put them in receivership and take them over. I mean, I know they can, but will they? I wouldn't see that happening. I think the more likely outcome is they say to hell with this and walk in federal court. That's what I would expect. Go ahead.
Yeah, so I do mostly real estate litigation. So there have been plenty of times where in various aspects, where someone has either appointed a receiver or I had to oppose the appointment of receiver. And basically what a receiver is someone who's a third party. Usually they're an accounting firm or something that knows how to, if it's an apartment building, they can run an apartment building, do all the accounting, etc. So it's somebody else that takes control over the business, and there has to be justification for doing that. And apparently the SEC and FINRA have that justification, or else they wouldn't have gone in and to shut those guys down. And they've acknowledged that. But as JR says, they haven't done that, because I've clamored about it for, I don't know, how many months have I been clamoring about it?
Since July, we've been talking about this.
Yeah. And part of the reason they're not doing it is because they're trying to assert the fact that they are independent of the court system, and that they have authority independent of the court system. And if they then, in this case, if they don't at least make the argument all the way, they think they're conceding that position by taking that to court. But in reality, that would be the prudent and the most effective thing to do. And if anybody ever gets a chance to speak to these bozos, I'd encourage you to offer that suggestion. I'm happy to speak to any of those guys or women, whoever is running the place. I know for FINRA, it's Mr. Cook. For the SEC, it's Mr. Gensler. Listen, anytime either Mr. Cook, I've heard you sometimes watch this live stream. So Mr. Cook, if you're watching again tonight, if you want to appear anytime, come on. We'll treat you nicely, and we'll let you say your piece. And to Gary, I'm on first name basis with Gary. To Gary, and some of you call him Mr. Gensler, that's also an open invitation to you. We'll even fit the timing to fit you if so if it need be. So we would welcome you on there, along with Elon Musk and Mark Cuban. Anytime they want to come on, feel free. But anyway, we'll have to see how that stuff plays out. Were you going to say something? You're again looking at the comments.
No, I was looking at the comments and and I was reading a couple comments as I'm hearing you inviting Robert Cook onto our show. So yeah, wouldn't that be hilarious?
Yeah, listen, maybe like if they thought they could be persuasive, they would come on, and I'm sure they would listen. They would deal with a very an audience that probably was somewhat skeptical. So it gives them an opportunity to, without interruption, other than your probably interruptions, to say their piece. We'd let them say their piece. So we welcome them. Listen, anytime. And I blame, if to the extent it doesn't happen, I blame busy brands, right? That's the only reason it doesn't happen.
Look, Robert Cook has 4 questions he needs to get his ass answering here pretty soon. So that's the way I see it.
What are the 4 questions? Because I know what they are. I know what they are for Passover, but what 4 questions were you talking about?
It's the 4 questions in Senator Crapo's letter. So
okay.
And then basically extended the SEC question. I mean, he's got a boatload of letters on his desk that he's trying to figure out what the hell to do with.
Yeah, so, I was thinking about that, and I wasn't going to talk about it, but since you brought it up, the letter, I was thinking if I was on, and again, this is not like we believe, although, so I'm going to pat ourselves on the back, even though we're certainly not securities lawyer and know nothing. Over time, we now believe that we understand the issues. And law school kind of teaches you, the only thing law school teaches you, I think it's a worthless most of the time, but it teaches you to kind of issue spot. So if you can figure out what the issues are, then you could figure the answers, because a monkey could figure out the answers. It's more kind of figuring out what the problems are. And we've been doing it for almost a year, and it's been intensive. And now we kind of have a good feel, I think, as to the things that we're doing, that we're kind of on the money as to what the problems are. And part of that, I think, is because issues that we've addressed months ago are now coming to the forefront. So we feel fairly comfortable about that. What were you going to say?
No, I was going to say you're spot on. That's what we were trained to do, is issue spot. And you and I have tried to articulate the issues where we think they're important, and we've focused on our conversations and research, on those. I hate to say it, but on those issues. So yeah, I mean you're right. But the amount of pressure right now that FINRA and the SEC are under is something that they've never experienced before from retail investors. I'm not suggesting that these folks have never experienced pressure, but they're seeing something they've never seen before. They're seeing a grassroots community push Congress to get answers. They didn't see that with all the GameStop stuff. This is new territory for them. So I can assure you, they are trying to figure out how to navigate it, and go back to Chairman Gensler's two testimony, or two. Can't even, I'm losing my train of thought. 2 appearances in front of congressional hearings, both the Senate Banking as well as the Financial Services Committee. He's dumbfounded. He has no idea how to respond to those questions, and you can see it all over his face. So this is all new territory for them.
All right, so I'm going to throw something that I hadn't really thought about before you raised it 3 minutes ago. So this would be me, now that it occurred to me, and it would relate to the letter that the senator sent that doesn't have a deadline anyway. If it were me, because this was my concern after thinking about it, I don't think, like, in my mind, the SEC, FINRA, whoever, those guys are not straight shooters. So to the extent they could be evasive in responding, they will be. And by the way, in litigation, just general litigation, when people are responding to discovery, it is an effort to get people to be on point. So
Right.
often people are evasive in discovery, and you have to press them to get the information you want. So
Right.
that's just kind of the nature of the beast. So that's how I see when I'm looking at these hearings, even though I'm not a political hearing expert, and there are. That's what I'm kind of thinking, that they are. It's shaped almost like a deposition. So one of the things I thought about, if I were on the bad guys team, the black hats, I would think, that, and by the way, this is not meant as any criticism, because if I was smart enough, I would have said this beforehand. So not meant as criticism to anybody. But I was thinking, if I'm on the bad guys, the term audited gives me a lot of discretion, because what happens if I want to hire a big 8 accounting firm to do this comprehensive project that lasts 6 months to give you an audited share count, because audited is pretty vague. So I was thinking about that. So I was thinking, so what do you do? What I would do is I would send, this is me, and not meant as legal advice or direction, but I would send an amended letter. I'd follow up the letter I sent, and I'd say, after contemplating what I asked, I think I'm going to add one additional category. And I noticed I also didn't give you a date by which a response was due. So I'll give you a response date. And I would add a 5th category. That would be an unaudited share count. I want both. So give me the unaudited, let them show me what they are presenting as the share count. And then I'll let them 6 months from now or whenever give me the audited share count. But I don't want to give them any reason to delay. So giving me the unaudited share count should be like in 15 minutes. That should be like a electronic printout. And by the way, and I mentioned this in a video last night, which was so brilliantly done and edited. Um, uh,
You lost your train of thought.
no, not choo choo. I'm still on the track. So in 2014, in a multi-year contract, the SEC contracted with Palantir. Palantir is this high tech data collection firm that basically, if you have all kinds of data, what it does is it finds it and then it categorizes it so you can make useful use of the data. So in this case, it'd be like when we talk about the blue sheets, that doesn't sound like what Palantir would do. Palantir would probably take the blue sheets and be able to categorize that in a way that would be helpful. And starting in 2014, the SEC started to use Palantir to find manipulative stock practices, insider trading, all kinds of gimmicky stuff. And they spent millions of dollars on this system. So they have everything. So
Right.
it's so the claim that they could not produce it is nonsensical. That's why they got the Palantir system. So I believe they could tomorrow provide the unaudited financial statements. And again, so I'm not telling anybody what to do, but if I were the senator's office, just to be clear, I would say I'd add the 5th category of unaudited share count, and I'd put a drop dead date. And I don't mean that any disrespect, but I mean, that's the date by which you need to respond. And if I sent the letter out tomorrow, so what's tomorrow? Tomorrow would be the 20th. I would give them 14 days to respond. And if they didn't respond in 14 days, I would follow up and give them some short period to tell me why they didn't respond or when they needed to respond. And after that, then I would move forward with a subpoena. That would be the way I would move. Now I understand Congress doesn't act precisely like that, but in a lawsuit, that's kind of how it would work. Try to work something out. But in a lawsuit, we would not be as nice in response. So the way I've gauged, and again, I appreciate whatever everybody's doing in the MMTLP situation, all the approaches to Congress. But in litigation, if I ask somebody once or twice to do something and they don't, that's it. I don't ask them 5 times. In Congress, I understand that there's more formality and in essence, issuing a subpoena is kind of like filing a complaint. It's almost on the same level. It has a level of significance more than it would for me. So I appreciate that. But it would be nice if we got a deadline date. Be nice, maybe perhaps if we open up another category of a response that would make them give a reply that they will be held accountable to, and then they would, because if they're giving a number and they know an audited number is coming that's substantially different, I assume there's going to be some disclosure, explanation, something. It's not going to be out of the blue. Anyway, that's something I thought about beforehand, and it came up when you were mentioning it. I don't know if you have any thoughts.
Well, I get that, we still don't have a letter with a date, and I'm not gonna. I mean, it is what it is. Every letter that gets sent to FINRA and the SEC is just one more turn of that vice. At some point, it's going to break through. At some point, there's going to be a tipping point with all of this. So I don't get hung up on what's missing from the letter as opposed to the letter itself. Crapo sending that last letter to Robert Cook is a shot out of the cannon. I mean, these guys don't get letters like that. They don't see this kind of stuff. Someone in FINRA is looking at this and having an oh shit moment. I mean, we know that, and it's no different than the oh shit moment they had on December 5th when they pulled those blue sheets. We don't see it, but I'm sure as shit 110% confident that someone is sweating themselves over all of this. So
yeah, it's the same. I think it's the same. I think it's the same shirt, by the way, that he's worn the last 19 days in a row, just between you and I.
Well, it's a flannel. It's cold in here. In my basement, it's probably 10 degrees colder than it is upstairs. I don't have heat down here. And so what I typically do is I grab a shirt that's in my office, and yes, it probably is the same shirt I've worn for the last 10 days. And you know what? So, I don't care.
Now, do you ever watch Charlie Brown on TV?
Did I ever watch Charlie Brown on TV? No, never saw it.
Okay. Yeah. Okay. So when like an adult is talking, the sound they make.
Yeah.
Wah, wah, wah.
No,
that's what it. Yeah, that is. It's that sound, and unfortunately, sometimes when you speak, I hear that sound. I don't know what to do about it. It's do you have any suggestions? That's true.
The audience is listening to me. I get more comments on there. Seriously, people are like, "Thank God you're on Richard's show to balance him."
Me too. I thank God for JR every day, and multiple times a day. By the way, and he knows. If
you'd listen to me, you'd have won your arbitration claim by now.
That's true. As opposed to being with 3 arbiters and
you're still trying to arbiters and a baby. The judge.
3 arbiters and a baby, I think what it is. Yeah. So just this is a side issue. Why, part of the reasons why the regulatory system doesn't work. So we're getting back to where we started. Elon Musk wants to unravel the existing regulatory system. So and we don't want it to be gone. We want it to work effectively. So you have to be careful. Somebody wants to dismantle it is on the same team, because they may not be on the same team, because Ken Griffin might want to dismantle it. And Ken Griffin, as we know, did you see that, by the way? He's building a $1 billion home in Florida.
Yeah, I saw that.
Most people need at least a $500 million home, but $1 billion, whatever. I think that's over the top, but that's just me. Yeah. But anyway, the point about the regulatory system, I think the problem is that the penalty system is not effective, and the reason why the penalty system is not effective because it's not set up to be effective. And And obviously, if the penalty system, this is my penalty system. This is not legal advice penalty system. So the penalty of if you're caught and you're found to have acted intentionally, then the penalty is disgorgement of any profit. So if you made any money, you got to give it back. A fine, penalties on top of that, plus the legal fees you had to incur. Right. So it cannot be economically beneficial to you. I don't care if you have to file bankruptcy. If that's the outcome, so be it. But you cannot get away with that. And I'm sure if you examined the system to date and you evaluated the fines and costs, they don't equate it anywhere near what the company makes.
Yeah, look, the system was set up by the foxes. You know, they're the ones that are assisting writing the laws and writing the penalties, and you know, it's a cost of doing business. We've talked about that 1,000 times. Go out on FINRA's website, you can see all the enforcement actions and the pennies on the dollar that these institutions are paying for the crimes that they're committing. It's an atrocity. It really is. It's disgusting. There's nothing American about it. These institutions, they're criminals. We talked about that on Sunday with the share lending program. That whole program is counterintuitive to anyone making money. And yet they're allowed to do it freely. No one pays any attention to it. When they do violate the law, they get a slap on the wrist.
Yeah, by the way, that was one of my, so I did serve some additional discovery in my arbitration, and I've looked through my 983-page customer agreement, and in terms of the disclosures regarding the share lending, I have not seen anything that equates to what actually happens. So one of the requests I made in discovery yesterday was I asked them to provide me each and every disclosure they provided with regard to their share lending program to me, and I'll see what it is. I can't imagine they disclose the fact that they'd be diluting my interest, that they'd be supporting naked shorting. My guess is there's no disclosure like that.
Yeah, I don't think you're going to find anything.
No, or they would take it.
I'd be willing to bet they argue that they shouldn't have to turn the policy over to you because the policy isn't relevant.
And what's interesting is, so everybody has to look at their own customer agreement, but it's probably like the same law firm that probably wrote it for everybody, so it probably has similar language. And I know people have talked about that New York case, the New York case, and just kind of let's put it in context again. So there was a case. It was up on a motion for motion to dismiss, which means that the party that filed the complaint had to justify why the case could go forward. And up to that point in time, in that particular courthouse, there was not a judge that said that the broker dealer had an obligation basically to pay attention what their clients were doing, because if they were engaged in misconduct, they could be primarily liable for the misconduct. It's kind of like I equate it to is, if you have a bank and some guy comes in and brings you $100,000 cash, you have an obligation to figure out what's the source of the money. You can't just take it. So right. I think this is equivalent. If you should know that your scumbag client is breaking the law, this New York case said if you prove it up, you could win on that claim. Now, it didn't say that particular defendant was liable. All it said was before this particular judge that she would not dismiss a claim based on that and would let the case probably go to either a motion for summary judgment or to trial. What were you going to say, JR?
Well, are you talking about what the case that Wes had, the Harrington case out of the Southern District of New York?
Yeah, where the judge imposed a duty, or recognized a duty on the broker dealers.
So I wanted to ask Wes a question the other night while he was on the space with Dr. Shapiro, and I didn't get the opportunity, but he talked about it. And, the way he was talking about it made me think, if there's now liability on the brokers for the wrongdoings of their clients on the other side of these trades, we know, Richard, that we have to go into arbitration against our broker dealer. So you have to go to Fidelity. I would have to go to Fidelity. But does this now open the door for me to turn around and sue the other 103 brokers for the wrongdoing of their customers?
Okay, so I'm going to be clear. So number one, did I cite that case this week in my arbitration? Yes, I did. Of course I did.
Should we put a poll?
Yeah. Yes, I did. But it's a judge in a courthouse. So it doesn't even mean the other judges in the courthouses, if they hear the same matter, have to follow that.
I agree, but I never take a look. You're taking a very narrow approach on the law, and you and I have had these philosophical conversations, and I always bring it back to the civil rights movement. Look, that's how the civil rights movement was won, just chipping away a case at a time in certain districts. And that's how you make broader law throughout the country. And so, again,
so I agree. So I agree. It opens the door because we know now this particular judge. We don't know how she's going to. I think it's a female judge. I believe. I think she, if it's a she, he, if it's a he, will apparently rule on this case. Now the case may resolve itself, so the issue may never be adjudicated. And if you're the broker, you probably don't want it adjudicated, right? So maybe the case just settles. That'd be my guess.
Right.
But to establish, so in terms of that, it may not go beyond this case. But we've established the fact that if this particular judge gets cases like this, she or he will certainly consider them. And there may be other courtrooms in this particular courthouse that have similar views. Now, it also may be the case that a judge may be the singular person deciding a particular matter. And I don't know in this particular courthouse if that's the case. So what I'm saying is maybe this judge decides every one of these cases. And if that was the case, then it would be more significant. But I don't know if that's the case. It's New York. I presume it's a big courthouse, and there's probably other judges that are deciding these. But it certainly would be persuasive enough that some guy in California would cite it in a Fidelity arbitration case, and everybody now who is proceeding against a broker dealer is going to cite it, going to give it a shot, because
why not?
Because some judges may pick it up and follow suit, but kind of like to again, and I'm more narrow because I do more litigation also. So I kind of, even if I'm not, ironically, what I do, I probably do more litigation than what a securities lawyer does, because if the case is good, it resolves itself. Not all cases I'm involved in resolve themselves, so I may end up in more trials, wherever that takes us. But we'll have to see kind of like how that plays out with other cases, and I think it definitely opens the door. It'll be interesting to see if an appellate court upholds that right, because that's when law is actually made. So if it goes up to an appellate court, the appellate court decides, yeah, I agree with this judge that there's a duty, and that's the issue, whether there's a duty on the broker dealer to know or should have known what was going on. That's the question. But until a appellate court decides that, it's not in effect precedent, but it can be cited as law. And I've blathered on and on and on and on. So go ahead, JR.
No, I was just going to say, I don't disagree with anything you say. I just, I go back to, and I look, I love to, first off, I love reading about the civil rights movement. Thurgood Marshall, and, what Dr. King did was just amazing. They forever changed the face of our country. People don't realize that they changed it through changing the law in the court system. So I tend to take, I've always looked at this issue, as a much broader issue. We talk about, and look, I know this is a touchy subject. So let me first and foremost say, MMTLP is always my priority. But when I look at this overall situation, I equate it to one of the aspects of the civil rights movement that Dr. King and Thurgood Marshall attacked. We're attacking MMTLP. We know it's an oversale. We know there's counterfeit shares out there, and it's all frozen in time. The evidence is right there. We just need to get to it. And so that's kind of my mindset. If we get to this particular aspect,
Thank you very much.
The other ones will get a little bit more easy. So and that's, in my mind, how we make change, the change that we all talk about on these spaces, and I'll tweet about and speculate on. That's how I envision making change. Now, that's not to suggest that this change gets that MMTLP gets solved in the courts. I'm just saying that it's a legal aspect, and we're taking a legal approach. And when I say we're taking a legal approach, I mean we're pressuring Congress for them to act on. Once we have the share count out, what happens after that? I don't know. But right now, getting that share count out is the first and foremost thing that needs to happen. And then once that happens with MMTLP, I can foresee it happening with some of these other heavily shorted tickers in OTC and in the mid cap space. So,
by the way, I should have mentioned, I did ask for, it's funny what I forget to say. In my arbitration, in the discovery request, I did ask for the Fidelity MMTLP share count, unaudited, audited, the NextBridge share count, audited, unaudited. Probably should have, I shouldn't have buried that, by the way. Just occurred to me. People have just kind of, to round this out, I see questions about what's going on about the appeal and when the brief is going to be filed. And I kind of occasionally make a reference to it. I believe that the FINRA has to file their responsive brief by the 28th of this month. Obviously, when that comes out, we'll talk about it and bore you to tears. But that's when we expect to come out. Now, the relevance of all that may have, we don't even know if it's relevant. When we got started on this, the idea was that GTII would squeeze when Alpine closed its doors. But since that, there has, am I correct? Anytime I misstate anything, JR, please kick me under the table. After that, then we kind of became interested in finger motion, and we noticed that finger motion and GTII had some connection.
Right.
So then people, including Ham, obviously, thought that, and William too, thought that finger motion would run first. But we have no idea, nor does anybody have any idea, really, in my opinion, when, if, how, whatever. But we still believe that GTII might be impacted if Alpine went out of business. But we have no idea. We have no idea if that would trigger a short squeeze. We have no idea if it would do anything. But since we started analyzing that, that's why we're discussing it. And as it turns out, besides our stock here, it might have a much bigger impact on the regulatory system. And that's kind of like evolved as we've been watching it. And it looks like, because, again, since, what my thinking is that there may be an appeal, depending on the outcome of the ruling of the Court of Appeal on this injunction, there may be an appeal to the Supreme Court. And since the Supreme Court is deciding an issue similar to the one that's considered an Alpine, but it involves an entity, FINRA, that's a private self-regulatory organization, it might be another case that the Supreme Court would want to decide, and would want to decide because maybe it would treat the SEC differently than FINRA. Maybe it would treat a private corporation differently, or a lot of people think that maybe it would treat the private corporation as a state actor. In effect, it was part of the government, and then it would be required to comply with constitutional requirements. A lot of people believe that too. But that's why we think that Alpine may ironically, end up going to the Supreme Court, because it's about FINRA, not the SEC, and we think it may be considered. I don't know your view on that.
I'm. It's kind of funny because you invest to make money, but when I look at MMTLP, GTII, and Finger, I'm just beginning to see. I'm beginning to see something much different than a squeeze or an investing or something like that. I'm starting to see these tickers as the push forward. First off, the communities are all very active. There's a lot of cutover in between the communities. MMTLP is the one that is frozen in time, and again, we're all shareholders. It's the one that's frozen in time, and it's the one that kind of needs to be resolved first. And I still think that it's going to be the domino that, I'm going to take a step back. I don't have this belief that it's going to break the market and, we're going to have nuclear, war in the financial industry and all that other stuff. But I do think in terms of change, I think it's going to have a significant impact moving forward in dealing with, the GTIIs and the Fingers of the world and the AMCs and the GMEs. It's the one investment community that has found success in moving things forward. I mean, that's the bottom line.
Oh yeah.
And so I just, again, I take this more holistic approach when looking at all this. And I was just on a space before we got on, and I'm still 110% confident at some point we're going to have the share count's going to come out. In fact, an individual had asked, do I think the subpoena is the best approach? And my response was, well, I think any approach that gets the final share count is the best approach. And it might not even be one we've thought of or seen yet.
Yeah.
We don't know what's out there. We don't know how this is going to resolve, but I'm 110% confident it's going to resolve at some point. It's that simple.
Yeah, you and I both agreed, and we all never knew how or why, but it's kind of, and it's difficult, obviously. All these tickers, it's difficult, but we figured collective pressure would eventually get the job done. That was it. We didn't know what, and I really do believe it's collective pressure. It's everybody banging on somebody's head. It really is. It really is. It's kind of like you see somebody in like a prison cell, and the guy's playing this loud rock music above him, and he can't get away from it. That's kind of it. We're just making lots of noise, and after a while, everybody wilts to it. Really. Yep. So what's interesting to me is in the current times because MMTLP is obviously not trading, so we're kind of waiting for that to resolve itself. And obviously, I'm personally involved in arbitration. We talk about this constantly. I know you're actively involved too. I know, because we talk about it all the time. But it's interesting that we walk, because so it's not trading, but Finger Motion's one we do watch, and it is amazing. I think it's incredible to watch how it trades. And you could tell just by the action, it certainly appears there's not a lot of selling, but the price action does not seem to reflect that lack of selling. So, and we talk about it like once a week or more. I'm sure we'll talk about it again Sunday night, but it's interesting to watch. Even some schmoes like us, when we look at it, you could tell something's amiss. Something's interesting going on. We know that there are parties that are maybe stuck in there, and we'll have to see how it plays out. Sounds like it's a very, very serious game.
I don't really watch the share price that much, honestly. In fact, I don't even think I looked at it today until the end of the day. I was busy with work pretty much all day. You look at it every 85 seconds,
Yeah,
apparently.
yes. We have the difference. So I do it for JR because he doesn't do it. So I do it every 85 seconds. So I send him a text, 682, 681.5. It's really helpful. He really does appreciate it.
Yeah, I
Yeah,
love it.
there's different kinds of people. I've always been attracted by numbers, so it doesn't make me anxious or whatever. But it's probably like a bad practice to look at the ticker every 85 seconds. That's just my I took a class in that. They said not every 85 seconds.
That's
Um,
not good stress management.
it's not. But I don't feel like that's why I have not in front of my name. I don't really feel stressed out though. So last but not least for this whatever this is, Mr. Musk has obviously now taken the first step towards kind of challenging the regulatory system. He has expressed uh, he was pissed off about the shorting of Tesla because it almost killed the company. And we can only, and it's, I know the last 3 months, and I guarantee you now, because he's had earnings kind of, sorry, sir, but earnings were not received well. They may have been fantastic, but they weren't received well. And so as a result, I think the stock's going to be even shorted more, honestly. So if in the last 3 months it was the most heavily shorted stock, over the next 3 months that will continue. And in light of what, and I don't know any of this for a fact, by the way. So again, this is all, as I like to say, pure speculation. But if it's true that all tickers are naked shorted and counterfeited, and most of the big stocks are to some degree, and if Tesla is ultimately, as it turns out, the king of the naked shorting stock, and if Elon is pissed off about that, as he's indicated, then he should take action here, because not only would he be well received by the retail community outside of Tesla, but the retail community inside of Tesla would be directly benefited by increase in the stock price. So, for example, that's, by the way, to follow that up, not only would the retail shareholders and institutional shareholders of Tesla be benefited, but probably the biggest beneficiary of this would be Elon Musk, because he has the largest ownership percentage of Tesla stock of anyone in particular. And if in fact the shorts were forced to cover, that would have a dramatic impact on the value of Tesla's stock. It would certainly increase the value of Tesla stock. And I don't think, and I didn't know this beforehand, but I see it done in lots of companies. And I know a couple years ago, there started to be discussions about a future dividend at Tesla. So I know one way that companies have tried to expose the shorts is by declaring special dividends and making the shorts have to produce those shares as to all shares that have been issued. I don't see, and I'm sure there's other ways that it can be done, but if in fact that's a method that's being used to expose the shorts, then certainly Elon Musk or whoever at Tesla should consider doing the same thing, or other tactics that expose the naked shorting. Because I think, if nothing else, that is substantial value that could go to shareholders. And I think it's undisputed that Tesla is the biggest victim of the shorts. People ignore it because it's a big company, because Elon Musk is rich,
Right.
all that stuff. But the facts are the facts. And I hear it every month. I hear Ham talking about it. And, to this point in time, the reason I'm bringing this up was because of this brief. This was the first action that I saw him take. I hope they file a brief in the ALPINE case, whether it be in the appellate court or if it goes to the Supreme Court. And I hope he takes action involving the naked shorting. Obviously, he could call up Wes, right? He could call up Wes and set up some system to deal with the naked shorting. He could call up. He has a relationship with Palantir. I think he could call up Palantir and perhaps gain access to their software or have them create a special software for him that lets him discover all the shenanigans that have gone on. I think that's also there is some connection between Palantir and Elon Musk because Palantir uses his Starlink satellite system, and they used it in Ukraine to provide intelligence to the Ukrainians. But anyway, but as I indicated, they also have the software that detects insider trading and all the manipulative practices. So I would think you might have access to that. But I really think this is a time. Ultimately, he asserts that he is a disruptor. If he wants to be the ultimate disruptor of the financial system, here is the time. Really?
Yeah, I agree.
Anything to add on that?
I don't follow Tesla like you do. In fact, I don't follow it at all. Although, I follow Musk on X, but that's about it. I don't own any Tesla. I know what they do, but that's the extent of my knowledge. So I would let you be the expert on that.
Yeah, it would be great. It would be great if he took the lead, and I think he could. And I think there are plenty of people out there that would assist him. And I think it would benefit him. It would benefit his shareholders. It would benefit. Listen, if Tesla took the lead in this, we could get this done. Really, if we had that kind of, if that firepower behind us, and again, it's not a case where he doesn't spar with the SEC. He's been doing it for years. He does not like them. He doesn't agree with how they treat him. He doesn't agree how they operate the system. And I think here at this time, he has the opportunity. So that's all I'm going to say about that. I hope since he's listening tonight, Mr. Musk, I hope you take that to heed and at least consider it. If you don't do it, at least consider it, because I really think you could be beneficial to all these tickers and be the leader and disruptor of the financial system. And somebody's going to do it at some point in time. If we are right, listen, if we're wrong, then we're wrong. Nothing's going to ever happen. But if we're right, and this is a endemic issue and problem with the system, at some point in time, it's going to crack open. Right. And why not let Elon be the one with his firepower, be the one who uses his resources to kind of spearhead this? So, because it affects him. So I'm hoping that somebody will talk to him about this and he'll take this in the light it's presented, because I really respect his ability to get things done. And I think if he targeted this as a cause, he could get this done. And since it appears that because of the economy and high interest rates, that perhaps he'll have less time to work at Tesla over the short term. So maybe this could be his new project and he could make friends of all of us on here tonight and all of us who are involved in all these tickers. And I can only imagine, do you disagree? If he came out, every retail trader would be in his back pocket.
I don't disagree at all. I mean, he's almost becoming like Alan Greenspan, where if he talked, whenever Alan Greenspan always had to be careful of what he was going to say, because his just uttering words moved the market. Musk is becoming the same way with Tesla. When he utters something, it impacts the share price, but he also, he can also move other things. I mean, look what he's done with Twitter. So yeah, if an individual like him comes out and starts talking about this, change would eventually happen, but none of us are Musk. So,
I know he's got tons of, listen, the guy works probably 24 hours a day, not exactly, but pretty close. So right. I'm sure he's got all kinds of priorities and responsibilities. That's that's obvious. But here's an area that that actually plagues him, that he's asserted is a problem. Mm-hmm. So it seems like something that he might be interested in taking on, and he wouldn't have to, it's not like he'd have to spend like on Spaces. he'd be spending time, every week on Spaces. All you have to do is put his support behind him, designate somebody to be, his spokesperson, and then let other people run, using his name and his presence. And right. I'm gonna bring it up, and I'm gonna continually, I have no disrespect for him. Again, I understand he's got all kinds of different priorities, but we're gonna bring it up and talk about it. And maybe if we talk about it enough, maybe at some point in time, especially if he experiences more of the downside of the shorting, maybe if he does, maybe at some future point he might be interested. So I hope it does work.
Right.
Anyway, anything else you want to talk about?
No, I think we covered. I think we've come full circle back to Musk. So
okay. So to everybody out there, we appreciate you being with us tonight. If you have, we're going to post this obviously up. If you have questions that come to your mind down the road, we're happy to answer them, because I do go through each comment. If you have a question, I'll respond, or at least look at it and draw a sad face or do a joke or say something, but we'll look at them.
Sad face and do a joke are the same thing, Richard.
Yeah, it's the same thing. Oftentimes after a joke, there is a sad face. So yeah, like I said before, JR, we started, I don't guarantee that any of my jokes are funny. I just guarantee that I will infect you. That's all. But anyway, we really appreciate everybody who's here. We appreciate everybody who comments and spends the time to be with us. And again, any additional questions, we'll try to respond. We're expecting to do another live stream Sunday with new and different issues. And again, we appreciate you being with us, and have a great evening. Anything you want to say going out, JR?
Good night.
Okay, great. Have a great evening. And we try to get out of here without being on the camera too long. That's the idea. So we'll see how it works tonight.